Chapter 7 School District Meetings. Where a meeting of a school district is held for a special purpose, all that is necessary in the form of the notice is that it should be so expressed as that the inhabitants of the district may fairly understand the purpose for which they are convened. It has been held that where the warning of a school society meeting stated the object of the meeting to be to take into consideration the expediency of raising money for the use of schooling for the year ensuing, such a warning was sufficient to authorize the laying of a tax for the purpose specified. The meeting should be opened in a reasonable time after the hour specified in the notice, and what is reasonable time depends, in some measure, upon the circumstances of each particular case, but a delay of 1 hour and 5 minutes is not, of itself, an unreasonable delay, there being no law necessarily requiring the meeting to be opened within that time. Of course, where the statute requires the meeting to be opened at a particular time, it must be followed. But an irregularity in this respect which does not affect the action of the meeting, nor deprive any elector of his voice in the deliberations of the meeting, would not, it is believed, render the acts of the meeting illegal. In New Jersey it was held that a special meeting of the legal voters of a school district may vote to raise money for school purposes, although such appropriation has been refused at the annual meeting. Where it appears that a site for a schoolhouse has been chosen, it will not be invalidated because the clerk has made irregularities or omissions in describing the site selected. Where it appears from the record of a school district that the meeting was held on the day appointed, the presumption of law is that it was held in suitable time in the day, and in pursuance of the warning, and if a party claims it to have been held otherwise, the burden of proof rests upon him. The intention of a corporation can be ascertained only by the language of its recorded acts, and neither the private views nor the public declarations of individual members of such corporation, can, for this purpose, be inquired into. Its records are proper and legitimate evidence in its behalf, of its votes, in a suit to which such district is a party. Under a statute which requires that school district meetings shall be called by posting notices thereof on the district schoolhouse and one other public place within the limits of said district, notice is posted one at the schoolhouse and one at the grist mill, both in said district, comply with the law and constitute sufficient notice. In New York it is provided by statute that the proceedings of a district or neighborhood shall not be held illegal for want of due notice to all persons qualified to vote thereat, where the omission to give such notice is not shown to have been willful and fraudulent.